And
save some bandwidth.
Okay, well, welcome to the June 2019 Planetarium Zoominar. And today we have a special guest, Chris Reed, who's going to talk to us about using music in your planetarium legally. So without further ado, I think Chris.
Well, thanks very much, Alan, and thank you all for joining. Thanks to PPA and again, Alan, for hosting this. Let me just make sure I can share my screen here. Okay, you should see a gray screen right now.
Yes.
And now you should see the presentation.
We see the first slide. Yes, works.
All right, excellent. All right, so as Alan mentioned, I'm going to talk a little bit for about 20, 30 minutes or so about copyright and music and how that all fits together with respect to licensing music and using music legally within your planetarium. To start, it wouldn't be a legal presentation without a disclaimer, and I didn't want to disappoint you. So just this standard disclaimer you've seen on, if you've ever seen articles I've written or really any lawyer's written. The information I'm sharing with you today is really sort of educational in nature. It's not intended to be legal advice. It's not a substitute for legal advice. What that basically means is we're going to talk in generalities. We're going to talk about the law. We're going to talk about general fact patterns and how the law might apply to those. But it doesn't apply to any one specific situation, particularly your situation. And so for those sorts of questions, you really do need to talk to your own counsel or lawyer. And the way I like to put that kind of in flip way is, although I'm a lawyer, I'm not your lawyer. So happy to present this information to you, but with that caution that if you have questions about any of these issues that kind of delve into specific questions about your circumstances, I'll have to encourage you to talk to your own counsel. The good news is those of you associated with institutions and museums and school districts and things like that have counsel almost certainly that are qualified to answer these sorts of questions. So quick background on me, since I suspect many of you don't know who I am and I haven't met many of you. I'm an LA-based media and entertainment lawyer where I practice primarily copyright law, but also do a lot of First Amendment, defamation, that sort of thing, antitrust and commercial litigation. I'm not in private practice now. I work for a large broadcasting company that you've heard of. It's not a secret. I just don't want to create the impression that I'm speaking on their behalf. So I'll just leave that out for now. Prior to coming to Hollywood, I was a policy advisor at the U.S. Copyright Office, where I worked with the director on a number of policy initiatives and helping her advise Congress on what copyright law should look like, where it needs to be improved, and that sort of thing. Before that, I was at the Justice Department in the Antitrust Division. And you may have seen my name floating around. I've been kind of dabbling in the planetarium community for many years. Back in 2005 through 2009, I wrote the general counsel column for IPS Planetarium, which provided information similar to what I'm providing today on a variety of legal topics, including music licensing and things like that. So quick snapshot of what I'd like to talk about for the rest of the time with you. I want to start with some copyright basics. I think this is, it's helpful if we're all on the same page about what copyright is, what it protects, how it works. So I'm going to start, real basic building blocks. Then I'm going to take those and apply them to music and explain sort of why music copyright tends to be particularly complicated and why specifically licensing music can be very complicated. We'll then take that and apply it in a more concrete fashion and look at how you can actually use music in your planetarium, the part you're actually here for. And then I'll try to leave a healthy amount of time for questions as well. So starting at the beginning, copyright, what is it? What does it protect? I think most of you probably have a good sense of what it means if something is protected by copyright. But again, let's start at the beginning. Fundamentally, copyright protects original works of authorship that are fixed in a tangible medium of expression. So what does that actually mean? Well, originality means that it originated with the author. It doesn't mean that it's unique. It doesn't mean it's novel. It just means you as a person created something that's original to you. In a practical sense, there's this doctrine in copyright law called independent creation. It's a little esoteric, but it's basically the idea is that if Alan and I separately come up with the same song unwittingly, we each own a copyright in that. It's not that my song infringes his song doesn't infringe my song. So that's what we mean by originality. It's original to some person or it's a product of someone's mind. And then by fixed, we just mean, and this is right out of the statute, so forgive the clunky language, but it means it exists in some physical medium for a period of more than transitory duration. And what they're trying to get at there is the idea that it is in a physical form long enough that it can be exploited in some way. Because the fundamental purpose of copyright is to provide creative people with an opportunity to get some return on their investment. So, in exchange for writing the next great novel or writing an amazing song, you have a limited period of time, the copyright period, to exclusively exploit that copyright to earn back whatever money you put into it. The idea being it incentivizes people to create things. So that is the fundamental building blocks of copyright. In a rare showing of utility, Congress has actually helped us out by putting it into a list of specific types of works that are subject to copyright protection. And so this is where things start to look a little more familiar. This list is right out of the law, out of Title 17 of the US Code. Literary works are protected, so that's books, journal articles, magazine articles, the written word. Musical works, we'll get more into detail on what specifically that means in a minute. Dramatic works, so those are plays, teleplays, screenplays in written form. Pantomimes and choreographic works is self-explanatory. Pictorial, graphic, and sculptural works, that's just visual art, right? So photographs, paintings, sculptures, any of that sort of thing, all subject to copyright protection. Motion pictures and other audiovisual works, that's where we see film and TV shows falling into. Planetarium shows as a show, a full show production would fall into that category. Sound recordings, we'll get into that in a minute as well, because that's what we're here for. And then finally, architectural works are also protected by copyright. Interestingly, architectural works are protected separate and apart from the drawing. So you can actually have an architectural work embodied in a house. So you could argue that the house is subject to copyright protection if it's sufficiently original. It gets kind of weird in that regard, but we see that a lot in copyright, these kind of little weird nooks and crannies of things that are protected that you might not think of. Okay, so we've talked now a little bit about the types of works that are subject to copyright, but what does it mean when something's protected by copyright? What does that actually get the copyright owner? And as we said a minute ago, the idea is it's designed to create an incentive for people to create new works by giving them this period of exclusivity to do something with them. Well, the law also provides a list of things that only the copyright owner is allowed to do or grant other people permission to do. And you see that in front of you now. The first one is really copyright's namesake. It's the right to copyright, the right of reproduction. So that's the obvious one. It is, you can't take a book and make a photocopy and sell that as a separate copy of the work. It's a violation of the copyright, right? Very simple. Prepare derivative works. So that's the next one. The most common application of this is probably adaptations. So when somebody takes a book and makes a movie out of it, right? The screenplay and then the subsequent movie are both derivative works of the original book. So only the copyright owner has the right to do that. And that's when you hear people talk about, licensing or selling the rights to do something, what they're really doing is selling the right to create a derivative work within a particular space. The right of distribution is fairly self-explanatory. That's the right to make a copyrighted work publicly available. I should note there's a limit to that. It's called the first sale doctrine, and that allows you to transfer ownership of the physical work once it's already been sold. So as a copyright owner, if I write a book, I own the copyright in that book, I have the right to the first lawful distribution of that book, but once it's in your hands, you have the right to do whatever you want with it other than make a copy of it. So if you want to then transfer it to a third party, there's nothing I can do as the copyright owner to stop you. That's why we have used bookstores and back in the day used record stores and things like that. There's nothing about copyright that prevents you from doing that. Other rights that exist that will become relevant here in a few minutes. Public performance, so the right to publicly perform or display copyrighted works is an exclusive right of the copyright owner. There's an oddity in US copyright law that is not particularly relevant to today's conversation, but it is relevant to music, so I just want to mention it generally. The United States is the only developed nation that does not have what we call a full performance right in sound recordings. Meaning that if when a radio station plays music on the air, they do not have to pay a royalty to the sound recording copyright owner, which we'll find out in a few minutes is usually a record label. So the record labels make nothing when a radio station plays their music, but they do make something, that is, the broadcaster does have to pay a royalty when it's transmitted digitally. And that, you can see, was a legislative compromise. The broadcasters don't like the idea of having to pay royalties, but the digital guys were seen as competition for the broadcasters. And so they did have to pay this royalty. And so Congress sort of slipped the broadcast industry a little bit of help in there. And it's a big policy issue right now. We're, like I said, we're the only developed nation that has this weird disparity in our copyright law. But the broadcast lobby has to date been very successful at kind of beating that back a little bit. Like I said, not particularly relevant for our conversation today, but I just wanted to mention it because it's a quirk, and it's hard to talk about sound recording copyright without that coming out. Okay, so we've talked about the type of works that are subject to copyright. We've talked about the exclusive rights that a copyright owner has. What happens if you don't have permission from a copyright owner and you choose to exploit one of those exclusive rights? We've probably all seen this scary looking notice at the beginning of DVDs and back in the day VHS tapes, at the beginning of movies, that threaten this horrible 5 years in prison and a fine of $250,000 if you're involved in reproducing the unauthorized reproduction or distribution of the film. This is true. However, it's a little overblown. The criminal statutes are, there is a path to enforcement through criminal law for copyright, but it is reserved for some of the most extreme cases. The far more likely scenario in an infringement context is through what we call civil remedies. And that includes an injunction against the unlicensed use. An injunction is simply a court order. So very often in a copyright infringement case, you will see the judge will order the infringing party to knock it off. Sometimes if there's multiple copies involved, if it's, somebody's made an illegal copy of a bunch of illegal copies of a movie, the judge will require that they destroy all those illegal copies, right? That's an injunction. The part that scares most people, though, is the money damages piece. And that can range anywhere from $750 to $30,000 per work infringed, if the plaintiff, the copyright owner bringing the lawsuit, can show that the infringement was willful, meaning you knew it was infringement and you did it anyway. You could be on the hook for up to $150,000 per infringement. And so this comes up fairly routinely these days in online file sharing cases where you might have dozens and dozens of works that are being infringed. And you can see that if the judge hits the defendant with the maximum penalty, you could be very quickly into the tens of millions of dollars because it's very easy to transfer illegal copies of things online. In our world, in the planetarium community, the likelihood, I would think, of seeing judgments that high is unlikely, but one hesitates to predict what judges and courts are going to do. The bottom line is, without a license, it's risky, and this is the sort of exposure we're facing. And so as a result, it's much easier and, frankly, in the long run, much cheaper just to get licensed. And so we'll continue to talk, as we go through this presentation, we'll talk more about what that actually means. One other piece of copyright basics I wanted to mention is this concept of duration. I'm guessing many of you on this call probably are aware of this already, but copyright lasts for a very long time. So I write a book today, and the copyright starts at the moment a work is created and finished. That copyright will last, if we're talking about a book I wrote, it will last for my entire life, plus an additional 70 years. And I can, just like any other property right, I can gift that to somebody. I can bequeath it to someone in a will. So my heirs will get the benefit of whatever copyrights I own for an additional 70 years past my death. For works made for hire, which is a special category of works where they're made by an employee in an employee-employer relationship, so works that I create for work are owned by my employer. My employer is deemed the author of those works. Those have a lifespan of 95 years after they're first published, or 120 years after creation. As a practical matter, you don't need to know those numbers. You just need to know that it's a long time, and that there's a very strong likelihood that something you want to use is subject to copyright protection. There's a lot of, people hope that things will fall into the public domain, and there certainly is a robust public domain, but the reality is most recently created materials are still going to be protected by copyright just because the term is so long. Okay, so that is a very, very quick run through of the very basic principles of copyright law. Now what I want to do is turn to music specifically and apply those concepts to the music context and see, first of all, why music licensing tends to be so complicated, and how we can cut through that and figure out what kind of licenses we actually need and how ultimately we can use music legally in the planetarium. So I want to go back to this slide for a second. You remember this from a few minutes ago. This is the list of protected types of works, right? Works of copyrightable subject matter. We're interested today in two of them. We're interested in the musical works, including any accompanying words, and sound recordings. So a musical work is the melody or the lyrics of a particular song. I think of it as the notes on the page, right? It doesn't have to necessarily be written in paper form, but it is referring to the intangible work that is the song. That is distinct from the sound recording, which could be, you could have any number of sound recordings of a particular musical work. And I'll show you an example of that here in a minute. But the key thing to remember here is they are two separate copyrights. So for every one song, you might have two copyrights. And we'll talk more about that here in a minute. In fact, we'll talk about it right now. So for every one song, we have potentially two copyrights. And where we have two copyrights, we very likely have two copyright owners, which means that to use one particular song, we got to talk to two different people. So that's kind of part one of why music licensing gets so complicated, is there's a lot of cooks in the kitchen. And we will see that indeed in music, the rights are typically owned by two different parties. One is a music publisher. They typically own rights in the musical work. And then the other is a record label, which typically owns the rights in the sound recording. They are generally different companies. Sometimes they are the same, that's pretty rare. And occasionally they will be, well, very often they're affiliated. So you might find a musical work that has been published by Universal Music Publishing, for instance, and it happens to have been recorded by an artist that releases on Universal Music's record label. But even so, they are still separate companies. They operate separately. They have their own management. They have their own licensing teams. And so you still, even if they have shared common ownership, very often have to talk to two different people. And again, we'll get into in a minute who specifically can grant what licenses and that sort of thing. Just to give you an example, I will use a pop culture reference for you. Taylor Swift, the musical works of Taylor Swift are owned by her. Taylor Swift Music is her publishing company. She is appointed or hired or works with Sony ATV, that's Sony Music's publishing arm, to administer her catalog. So if you want to use a Taylor Swift musical work, you've got to go talk to Sony ATV. The sound recordings are owned by somebody else entirely. That's owned by Big Machine Label Group, which is a record label. And so if you wanted to use an original recording of a Taylor Swift song, you would have to go talk to them, as well as the musical work copyright owner. This means that under US law, you can actually create your own covers of other people's songs. In that case, we're not using the sound recording, we're just using the musical work. And so the only people we have to pay in that instance are the musical work copyright owner. So again, I'm just giving you examples of how those two rights are split, even though we're talking about a singular, quote unquote, piece of music, right, in the context of a commercial recording. So this is an example of something where both the musical work and the sound recording are protected by copyright. Here's an example that might resonate more with the Planetarium community, Holst's famous suite, The Planets. That is a musical work that was first published back in 1918. That has been in the public domain for some time. So there is no copyright on the musical work. Again, the notes on the page. Anybody could create a recording of The Planets and sell it or do whatever they wanted with it. There's nothing that the Holst estate could do because they don't own any rights anymore. They've long since expired. However, in this particular example, that cover art I'm showing you right now, that is the Chicago Symphony Orchestra's 1991 recording of Holst's The Planets. That is subject to copyright protection, owned by the Chicago Symphony Orchestra or whoever they may have granted it to. It might be a record label, might be them. But the point is that is still protected by copyright. And so where a lot of people make a mistake is they think, oh, I've got this classical recording, everything's fine. And they find that actually that recording is owned by somebody else and they may come after you for an unlicensed use. So you have to be very careful to make sure that both of the copyright interests at issue are taken care of when you're using music. Okay, so we've talked about the type of copyrightable works that we're interested in from a music licensing perspective. Let's look at the exclusive rights. Right? We had to put this big list up from earlier. You'll remember there's two of them, just as there are two types of works. There are two rights that we're interested in for each of those as well. So the first is reproduction. If we are creating a Planetarium show soundtrack, we are necessarily making a copy of the musical work and the sound recording and fixing it with voiceover, narration, special effects, and connecting that with visuals that appear on the dome at the same time, right? So that is considered an exploitation of the reproduction right in copyright parlance. The other right that we need to worry about is the right of public performance, because we're not just going to create that soundtrack and then let it sit on the shelf. We're going to play it for audiences. And so that's considered a public performance. Just to knock out a couple of common questions, yes, it is still a public performance, even if it is a private show. The definition of public is anything outside a normal circle of family and friends. So if you're only playing it in your living room and it's your family and maybe a couple of friends from down the street, that's a private performance. We don't need to worry about copyright for that. But a public performance, we do need to worry about. And so that's the second piece of this. And this includes, by the way, not just show soundtracks, but also music that you might be playing in the lobby as background music you might be playing in queuing areas, or as pre-show seating and post-show exit music. That's all considered public performance, even if you're not reproducing it. So you might not be worried about the reproduction right for those situations, but we do still need to worry about the public performance right. So going back to this for a second, not only do we have one song, but we've got two copyright owners, and now we've got two separate rights at issue. So that's why music licensing is so complicated, is because we've got this sort of this grid of licenses or of rights that we need to worry about licensing depending on what our use is. And of course, the music industry has its own terms of art, because nothing is simple. And so we could put these up in chart form. Let me just, I screwed up the animation on this, so I want to make sure I pull up the right things. All right, there we go. So along the top there, you will see the rights that are at issue. And along the left side, you will see the copyrightable works at issue. So the exploitation of the reproduction right of the musical work, we call that synchronization, or sync for short. So if you call up a publisher and say, hey, I need a sync right, or sync license, they'll know what you're talking about. And it's called that. It's not called the reproduction license, even though that's the technical copyright language that we would use. It's called a sync license because that's basically what you're doing, right? You're synchronizing that with visuals on the dome, or in a video project, or whatever it is. You're affixing the sound, the music with other sound and with visuals, synchronization. The reproduction right in sound recordings is sometimes also called sync, increasingly, but it can also sometimes be called the master right, or you need a master license. That's because the recordings that record labels have are called masters. And so if you want to use an original recording of something, you're asking to use their master, basically. It doesn't matter that you don't actually want their copy of their actual master, but you're using some derivative of their master recording. Technically, a master license is broader than just synchronizing it to a soundtrack or using it in a soundtrack. So that's why I've noticed sometimes they'll also refer to that as a sync license. It's a little confusing then, because we're talking about a sync license for a label, for a sound recording, and a sync license for the musical work. But generally, that's the vocabulary that's used. It's either the master or the sync. On the public performance side, happily, we don't need to worry about public performance on the sound recording, because remember, we don't have that right in our copyright law. Very odd, but we don't. So we don't need to worry about that. We do need to worry about it for the musical work. And that, happily, is just called the public performance license. It's not that complicated. It's probably the only intuitive thing about music licensing. And those are fairly straightforward. We'll talk about those here in just a minute, about how you get those and where they come from. That's actually the easiest part of all of this. So we'll actually talk about that right now, where they come from. So the sync licenses, you have to go to the publisher or an agent of the publisher. A number of music publishers, they have direct portals now on their website where you can approach them about licensing, or you can go through an agent. A lot of them have deputized a company called the Harry Fox Agency to grant licenses on their behalf. You may also see, if you go to the Harry Fox website, you'll see a lot of references to mechanical licenses. That's something else. We don't need to worry about that for present purposes. That's for making copies of things. So if I wanted to make a CD, I wanted to make 500 CDs of somebody's music to sell, I would need to pay for what's called a mechanical license. That's called a mechanical reproduction. But we don't need to worry about that here, because we're talking about using music in your planetarium. And actually, now's a good moment to say something I should have said earlier. What I'm discussing today is focused on using music in your own productions and in your own facility. If you want to use music online, it's a different set of rights we need to think about, a little bit different. And if you want to sell or license those planetarium productions to other facilities, that's also a separate kind of licensing discussion. I'm not talking about that today. This is really just focused on what you need to use music in your own facility. So continuing here, for a master or sync of the sound recording, you go to the record label. And then for public performance, you go to these four what are called public performance or performance rights organizations, or PROs for short. I suspect most of you have heard of at least the first two, ASCAP and BMI. They've been around the longest. They're the most prolific. Back in the early 90s, this other one called CSAC popped up and started doing the same type of thing. And then GMR came onto the scene just a couple of years ago. Global Music Rights is what that stands for. The challenge with our licensing scenario in the United States is that because we have four of these organizations, to be fully covered for performance, you either need to be very specific about what you're playing and know which license agencies have those licenses, or you need to get a blanket license from all four of them. And that's not as onerous as it sounds. We'll actually get to that here in a second. So now we're moving into kind of the final part of this conversation, which is how you actually would go about using music legally. We're going to put everything we've learned together and look at three ways that you might use music legally, or safe ways to use music. And the first thing I want to knock out is the performance license, because they're licensed on a blanket basis, which means that you go to ASCAP, BMI, CSAC, and GMR, and you get a license that covers everything in their catalog. You don't need to tell them specifically what you want to play. It's just, if you have an ASCAP license, you play anything that's in the ASCAP catalog. You have a BMI license, you play anything in the BMI catalog. The challenge is it's sometimes difficult to figure out what's covered by which license agency has rights to what. And to be safe, most heavy users of music, high volume users of music, have a license from all four. So all broadcast radio and TV stations, for instance, have licenses from all four of them. There is a strong likelihood that those of you in larger institutions, school districts, museums, already have these licenses in place. Music use is so ubiquitous, and the potential risk of not having it licensed is so high that most large organizations have already taken blanket licenses from these guys. And this is one of those things where you'll want to talk with your administration or your general counsel to confirm that. But there's a strong likelihood that you've already got these licenses. And you can see that picture there. That's from the door of a restaurant. Back in the 80s, they were very big on sending these decals out to everybody to show that the bars and restaurants and things were using licensed music. So ASCAP, BMI, and the others are very good at making sure people know that you owe them money if you need a license. And I suspect they've been just as effective at doing that with the museum, science center, and academic community as well. I know most major public school districts have them, and I suspect it's true of most other large organizations. Okay, so I've kind of broken this down into three categories. The first way you can use music legally, that you've probably deduced from the conversation thus far, is that you can just license commercially available music, such as something from Taylor Swift or a recording of Holst, through the publisher and the record label for particular use. And it's, I make it sound so simple. It's a bit of a pain, but it can be done. You can go to the label and you can say, I want to do this, and they'll give you a rate, and you pay them and they send you a license. And it's fairly straightforward. It's got some pros and cons. The pros are, of course, you're using popular and familiar music, and you get a very clear, the license is very clear. You can do what you want to do with the music, assuming you've told them what you want to do with the music, and you pay the money, and then you've got the permission to do it. The drawback is it can be very expensive. Some of these rates can be in the tens of thousands of dollars to use commercial songs, and that's just because the labels know that they effectively have a monopoly over those particular recordings, because that's how this works, right? Copyright's sort of a limited monopoly on a particular piece of work. The negotiations can be time-consuming. And perhaps more importantly, it used to be, I think it's getting a little better from what I've heard, but it used to be very difficult to get the big publishers and labels to pay any attention to you unless you were another big company. So if you were a large, film studio or TV studio or broadcaster, they would talk to you. But if you were, your average planetarium or a school district or some other smaller enterprise, not a heavy user of music, it was often hard to get their attention. I have heard that it's getting easier, and I have heard that some of them were getting together to create online portals that made all this, easier and streamlined. And I think the thinking was they knew a lot of people were infringing on their stuff, using the music anyway without permission, and they figured the internet's made things a bit easier to, put buyers and sellers together. Might as well harness that and capture some more revenue. So, like I said, I don't have any firsthand experience with the latest sort of structures for doing this. The easiest way to do it from my perspective would be to get on the phone with their business affairs departments. That's usually who you're trying to get a hold of. Business affairs are the departments within the publishers and the labels that deal with these sorts of licenses, so they can help you Or, like I said, internet research to see if you can find a faster, more efficient way of doing it these days. Okay, so at the other end of the spectrum, you could commission custom music from a composer, excuse me, under a work for hire agreement. So what this is you go to a composer and you say, I'm producing a planetarium show and I'd like you to do the music. And copyright law allows you to enter into what's called a work for hire arrangement, which basically says that although, Joe Composer is doing the work and composing the music, I, Planetarium, are going to be deemed the owner of that work. And the benefit, of course, of this is fairly obvious. You own all the rights. It's your music. You can do what you want with it. You can put it in the show. You can sell a soundtrack. You can use it as pre-show music. You can do whatever you want with it. You put it on the internet. And the other advantage, obviously, from more of a practical perspective, is it's customized to your production. So it's fixed with they've heard your narration, your voiceover, and they know where to put the music in, and you have some control and in the creative process over that. The downside, taking the second bullet first, is that it's time consuming to do that. It takes a lot of time. You go back and forth. I'm sure some of you on this call have done custom music, custom scoring for productions, and it takes a long time. It can also be very expensive. Composers don't work for free. Having said that, the internet, again, amazing, has opened up all sorts of opportunities for freelancers, and there are platforms like Upwork where you can find composers and things like that are willing to work at perhaps less than rates that you might be familiar seeing. But that's another option. You can take custom create it and take the ownership, and then you don't have to worry about any of this because it's yours. And then finally, this is my personal favorite option because it's kind of in the middle. You're using music that's been pre-produced, but it's been produced for the purpose of being incorporated into other productions, meaning it's production music from a commercial music library. And the three big ones that come to mind, there's dozens of them, but the ones that I've had experiences with are APM, which is Associated Production Music, Warner Chappell Production Music. Warner Chappell is a big music publisher, but they have a production music arm called Warner Chappell Production Music. Killer Tracks is another big one. I think Universal has a big library out there. The advantage of this is it's a one-stop shop for master and publishing rights. Music libraries control both the master and the publishing. So you don't have to mess around with multiple licenses. You just get a license from them, tell them what you want to do, they give you a rate, you pay it, you're done. They all have online catalogs. You can listen to samples. You can put the low fidelity samples into your production and kind of see how it sounds before you license it. They have a broad selection of genres and styles, so you have that to work with. The downside is, and sort of the flip side of the genres and styles, it's typically written for broadcast or theatrical use. So they tend to be these grand, epic kind of pieces, or they're cut for broadcast use, meaning they're in 10s, 20s, 30s, and 60s for commercials and promos and things like that. There's also a broad spectrum of quality. You've got some of the lower end libraries that do royalty-free licensing, which means you pay once and you can use the music forever and ever. You get what you pay for. The higher end libraries, you pay per use, you pay per track, you pay per license. So you pay a bit more, but the quality tends to be a little bit higher. One word of warning about the royalty-free libraries is that often the licenses they're giving you are not as broad as their marketing materials represent. So you want to be very careful to read through what the license actually allows you to do. Just a word of caution there. And then I would be remiss if I didn't mention, there are a couple of music libraries that I'm aware of that are specific to the planetarium community that don't suffer from some of these infirmities. They're the ethereal sort of music that we're used to hearing in a planetarium. The two that come to mind most notably are Geodesium from Loch Ness Productions, and I believe John Serry has a library out as well. And I think IPS on their website has a number of tracks that claim to be cleared for IPS members to use in their productions as well. So a couple other sources of library music. So again, something in the middle. It's not custom, but it's also not like widely used commercial music. So it's a little bit easier to license, a little bit easier to manage. All right, home stretch. I just want to go through a couple of things I often hear. Why can't I do this? Why can't I do that? Why does it have to be so complicated? And the first one is, well, why can't I just use Spotify? Why can't I just use Apple Music? I already have a subscription. I pay my $10 a month. I'm just going to do that. And the reason lies in the terms of use that none of us, including me, ever read. But this one I did for this presentation. This is a week or two old screenshot of the Spotify terms of service. And you'll see right there in paragraph 1, it says you can't do all of the things that we need to do to use this music in a planetarium. There's no public performance. There's no reproducing. There's no performing or displaying to the public. And the reason for that is that Spotify is a consumer-facing music service. It's not designed to facilitate that kind of of use. And so they don't have, Spotify does not have the rights to give to you because they didn't get them from the publishers and the labels, right? When they set up their service, they had to get a bunch of licenses, and what they told the record labels and the publishers they were doing was making music available to average users to listen to for personal enjoyment. So they simply don't have the rights to give you, which makes it unlawful for you to then use that in this sort of context. And this is true. This is just an example. As I say, it's from Spotify. I haven't undertaken a comprehensive study of all the other ones, but I guarantee you they're all more or less the same, just because that's how this industry works. So that's why you can't just use Spotify. Another thing I often hear about is, it's an educational show, so it must be fair use. And therefore I don't need a license and don't need to pay for anything. So fair use is an exception to copyright law that allows you to use certain limited portions of copyrighted works for teaching, commentary, criticism. It was really designed as a safety valve to copyright to protect certain First Amendment free speech issues. Because if you think about it, copyright is really protecting or preventing you or me from using certain forms of expression for a limited period of time. So an example would be if you wanted to write a negative book review about my book, you wouldn't come to me for a license to use excerpts from the book. I'm never going to grant you that license because you're going to say bad things about the book. But fair use allows you to put those quotes in a review because you're making that commentary and that criticism. The challenge with fair use is that it is famously fact dependent. So it's very difficult to sit here in the abstract and go, oh yeah, that's fair use, that's not fair use, that clearly is, that clearly isn't. The reality is we don't really know until a judge has decided what it is. The fair use doctrine or the fair use section of the Copyright Act gives you a list of things to think about. And then over time, judges have thought about them and decreed, what is and isn't fair use. And so what we do as lawyers is we go through and we look at a particular use and say, yep, this looks an awful lot like these three things, and that was fair use, so we think you're okay here. Or, nope, that looks an awful lot like this thing that wasn't, so don't do that, let's get a license. In the context of music on the Planetarium, it's not, typically you're not using the music as part of the teaching or part of the educational mission. It's more of a side, it's designed to enhance the appeal of a particular show, but it's not, you're not teaching about the music, right? You're not teaching about the copyrighted work. So it's very hard, I think, to make a fair use claim in that environment. And the example I usually use is if I were teaching a class in the Planetarium about using music in the Planetarium, then I think my music use would be fair because I'm showing you them as examples and I'm trying to explain, this is how you might do this sort of technique or that sort of thing. Whereas in a typical Planetarium show that's just put on routinely, the music is there purely as almost like decoration, right? You're not doing anything with it that would trigger those sort of fair use-y type concepts that we typically think about. So I think that's a really risky way to go, just claiming that everything's fair use because it's educational. And then finally, I wanted to mention Creative Commons licenses. Some of you may have heard of these. These are, there's an organization called Creative Commons. It's a nonprofit. And they've come up with a set of structured licenses that copyright owners can apply to their works. And we've seen as a result of that, a host of websites popping up saying, well, we're your go-to resource for Creative Commons licensed works. And a lot of Creative Commons things let you use their work for free as long as you provide attribution or as long as you allow people to share the work, you share the work that you create using the other person's work on the same terms and things like that. That's fine, and I think that's great that exists. One of the challenges I've noticed, though, I haven't seen it with music, but I've seen it with visual arts a lot, is that a lot of services, when people they're not careful when people upload things. So it defaults to like certain photo sharing sites, for instance, people were uploading images that were defaulting to a Creative Commons license so that when you or I go by and find that image through a Google image search or something, it says, oh yeah, this is licensed under Creative Commons. Well, the person who put it there had no idea. And so then they see your use of that image and they hit you with a cease and desist letter and, what we call a nastygram and all that sort of thing. Worse, I've seen a couple situations where somebody stole a photo and then uploaded it to one of these Creative Commons platforms. So the person who actually took the photo, the actual copyright owner, had nothing to do with the Creative Commons license. And there's a saying in the law, you can't get title from a thief, which means the thief cannot license you. The fact that you didn't know that the original copyright owner had never granted that license is irrelevant to the copyright liability equation. So I'm skeptical that these Creative Commons platforms are safe to use. I think it's great that they exist, and I think it's great that copyright owners have that flexibility to make things available under these kind of license terms. But for this sort of use, commercial use in a production setting, I'd be very leery, and I would use one of the big commercial music libraries or one of the other things that we talked about, because you're getting, typically in those contexts, you're getting some sort of guarantee, or what we call a representation and a warranty, that the person granting the license has the authority to grant that license. So I'm not saying don't use Creative Commons stuff, just be very careful when you do. And so with that, that's sort of the end of my prepared remarks. I see I've gone over time a little bit, but I'm happy to entertain any questions or comments you may have, subject to the caveat that I can't provide specific legal advice, but I'm happy to chat further.
Chris, I'm going to stop the recording and restart one for questions, but
Sure.
If everybody at this time, could you unmute? I think this was a great presentation. Let's give him a round of applause. Thank you, Chris.
Thank you.